Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers judicial proceedings, the Tennessee Public Meetings Act, and resisting arrest, and is brought to us by Shields of Shame's channel. Be sure to check out the description below and give them the credit that they deserve. On November 6th, 2021, journalists David Toulis and Christopher Sapp attempted to cover a meeting of the Tennessee Municipal Judges Conference, which was held at an Embassy Suites location in Franklin, Tennessee. Conference organizers informed them that the meeting was closed and asked them to leave. When the journalists refused to leave, police were called to the hotel, and the encounter that followed was captured on the body camera of Officer William Orange of the Franklin Police Department.
So what we have is we've got somebody in there that doesn't belong in there. So we need them removed. But as I understand it, the hotel has to tell you that because they're on their private property. Is that correct?
I would need to check on that. I mean, you guys are running the conference?
Yes.
Okay.
Yes. So, but there is a gentleman in there that needs to come out.
He's refusing to leave?
Yes. And then these guys out here are trying to tie everything up that it should be an open meeting, which it is not.
Okay.
So.
All right. And what's the question?
What's that?
What's the question?
Well, they're not letting the press in here. And the Tennessee Constitution, Article 1, Section 19, it says that the printing press is free to every citizen to examine the proceedings of any branch or officer. And so, we've got the administrative office of courts here controlling entry, and so this is a proceeding of a branch of government. And they're acting unlawfully by preventing the press from going in. So I'm just here watching that. I was hopeful that they were going to be allowed in there. They're talking. They're conducting business in there.
1 second. What's that? Sir, you've been asked to. You're not allowed inside. Okay?
I'm a member of the press.
I understand that, but there's also sides to a public meeting. It's not a public meeting.
Public meeting. That's right. It's a public meeting.
meeting.
It's a public meeting. Thank you, officer. That is correct.
That's fine.
And it is a public meeting, and we're paying for it by taxes.
Okay. Well, they have stipulations stating that you have to be invited.
Yeah, but stipulations don't overwhelm the constitutional right in Article 19.
No problem. You'll have your chance to address that later, but as of right now, they do have a sign up saying that it is a closed meeting.
They've got the administrative office of courts here. That makes it's public. It's a proceeding.
Okay. Well, I don't know what capacity they're here under. I don't know if it's.
They're judges. Yes.
Okay. You should be concerned as a citizen. That we've got a branch of government acting without transparency. My name is John Gentry. I'm a candidate for governor, and the press just asked me to come down and witness this today. What's going on? A large part of my platform is reforming corruption in the judiciary. You get to be a judge.
I don't know, man. All I see, and believe me, I'm just walking up here. I don't want to steal anybody's rights. But I see a sign posted right here, only conference members and staff permitted in the session. So
you should be extremely concerned as a citizen of this state that you've got a branch of government acting without transparency. And I would say, are they doing something wrong? Like, why would you not want the press in there?
Political candidate John Gentry and Mr. Toulis both argue that the press has the right to access the conference meeting under the Tennessee Constitution. Article 1, Section 19 of the Tennessee Constitution states that, quote, "The printing press shall be free to every person to examine the proceedings of the legislature or of any branch or officer of the government, and no law shall ever be made to restrain the right thereof." Now, in addition to this right, as the Court of Criminal Appeals of Tennessee noted in the 1998 case of Knoxville News Sentinel versus Husky, quote, "The Tennessee Supreme Court has recognized a qualified right of the public, founded in common law and the First Amendment to the United States Constitution, to attend judicial proceedings and to examine the documents generated in those proceedings." However, as the Sixth Circuit Court of Appeals, which has jurisdiction over Tennessee, explained in the 2016 case of Phillips versus DeWine, quote, "The right of access to government proceedings is not a tool for judges to pry open the doors of state and federal agencies because they believe that public access to this type of information would be a good idea. It is a qualified right to certain proceedings and documents filed therein, and nothing more. Therefore, it is essential to understand that these access rights attach only to judicial proceedings, meaning the formal acts of courts in administering justice, not to every meeting involving judges. While courtrooms generally must be open to the public when court is in session, the requirement does not mean that any gathering of judges constitutes a so-called court that must be open to the public. The Tennessee Municipal Judges Conference was created by Section 17-3-301 of the Tennessee Code, which states that, quote, "The conference shall meet annually for the consideration of any and all matters pertaining to the discharge of the official duties and obligations of its members, to the end that there shall be a more efficient and prompt administration of justice in the municipal courts in this state. The annual meeting shall provide educational seminars or training for the membership in addition to the business sessions." Now, because a right of access exists for legislative and government rulemaking sessions, there may be an argument that any so-called business sessions of the Judges Conference must be open to the public. However, the agenda for the conference shows that on the date of this encounter, Mr. Toulis was attempting to access an educational session on so-called sovereign citizens. Therefore, it is likely that a court would conclude that there was no constitutional right for the press to access the closed continuing legal education session of the Tennessee Municipal Judges Conference, as it was not a government proceeding.
You know, our legislative process.
It's not allowed in?
What's that?
Are you the only press that are not allowed in?
I'm not trying to get in. I'm a candidate for governor of the state of Tennessee, and I'm a
So
large part
they're
of my
not telling
work.
you to stay out?
No, I'm not.
So then why, who are we talking to that said, they said get out?
Press.
Hey,
Okay, all right.
I'm with Nuka Radio in Chattanooga.
Okay.
Officer Jay Carson is at the town of Franklin.
Yeah, I don't know. This lady in the mustard color behind us, the trooper asked when we got here if she was alerted by her supervisor if we could get someone from the hotel to say, hey, they're not welcome. And I brought that up to them. At the time, they said they weren't comfortable with that. And again, see a sign, only conference members and staff permitted sessions.
Well, who is renting it? Do we know?
I don't know. I would assume the girl working extra job.
Apparently there's still somebody inside, correct?
I don't know.
Did you go and check to see if...
I talked with them at the front desk. They said, no, we're not comfortable with telling anybody they're not allowed to be here.
Okay.
But they're not allowed to be in here. If it's a closed session?
I assume
doing it
if
here,
I
why
was
are they
renting
doing
a
it
hall
here?
for my birthday party and someone came in, I said, hey, no, you're not invited to my party. But, man, you start getting in the
Yeah,
press and, man, I don't know.
but he didn't want in there.
Not the governor.
Right.
The guy's running
The guy
press,
filming.
and supposedly there's still a guy in there that they want removed.
Well, that's what I think troopers for.
You want to talk to her, Jenny?
Yeah. So is there still somebody in there that you won't move? Okay. What is he? Or this person? There's a member of the press?
Yes,
Who rented this? Who held this? Do we know?
that I do not know. I'm
Because
the
the hotel
AOC,
is giving us the thing of the they don't want to get involved in it.
Right.
So it's
I
one of
would
those.
think the AOC reserved
Yeah,
rooms in this
would
room
be one would
on
think.
behalf of the conference.
So this other person that's in here, he's with the press.
Yes.
Is he causing a ruckus, or is he? Do you know? Is he?
He's just sitting right here in the back.
He's running his pencil.
That's all I got. I like that. I use that one. Okay. Have you asked him to leave?
Repeatedly.
And he says no.
But they're not gonna further their discussion in there with the non-members.
Right.
I mean, it's,
So let's say non-member. I'm trying to think if it'd be trespassing.
No, it can't be trespassing.
Yeah, I know
Because this there's been an easement. This is a government operation right now. It's a government
I
property,
think
effectively by
it would
easement.
only be if the hotel said that.
Yeah, and the hotel says they don't want to get involved.
Right, right.
So then it gets into a private property issue when it comes to the hotel.
Right.
We've asked this guy to leave. As THB, we've asked him to leave, and he refuses to leave.
Correct.
On the basis
He's
of
there.
it being members only type thing?
Correct.
He's there under Article 1, Section 19 of the Constitution, freedom of the press.
Right.
And also the Open Meetings Act, which says no government business shall be done in secret. And that's what's happening here. It's being done in secret. And this cannot stand.
Yeah.
It simply cannot stand. It's not proper.
I'm wondering why they chose a public venue like this instead of like the Capitol to do something.
Well, I mean, it's just
Now, are they?
it's a conference for the members that
yeah.
are a part of the conference.
Yeah, I got you.
Mr. Toulis argues that the so-called Public Meetings Act does not allow the conference to be closed to the public. Well, according to the Tennessee Public Meetings Act, which begins in Section 8-44-101 of the Tennessee Code, quote, "The General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. To this end, Section 8-44-102 of the Tennessee Code states that, quote, all meetings of any governing body are declared to be public meetings open to the public at all times. However, the statute clarifies that a so-called meeting is defined as, quote, the convening of a government body of a public body to make a decision or to deliberate toward a decision on any matter. And a so-called governing body is defined as, quote, the members of a public body which consists of 2 or more members with the authority to make decisions for or recommendations to a public body on policy or administration. It is not entirely clear whether the Tennessee Municipal Judges Conference would be considered a so-called governing body, as Section 17-3-301 of the Tennessee Code does require the conference to meet, now quoting, for the consideration of any and all matters pertaining to the discharge of the official duties and obligations of its members, to the end that there shall be a more efficient and prompt administration of justice in the municipal courts in this state. However, it is unlikely that the educational session that Mr. Toulis sought access to would be considered a so-called meeting for the purposes of the Public Meetings Act, as the statute only requires governing bodies to hold open to the public meetings that are held to make a decision or to deliberate toward a decision. Because the judges were convening to receive educational instruction rather than make decisions, it is probable that a court would conclude that the Public Meetings Act did not require the educational sessions of the conference to be held open to the public or the press.
Well, let me go make a phone call to my higher ups because I don't know. This is going to be one of those challenges that this is going to be.
Before you guys got here, that was what my chain advised. Like, hey, you need to get the hotel to declare them trespassing.
and
Otherwise,
the hotel
we
doesn't want
really,
to. We really can't.
Yeah.
Unless the hotel says.
I mean, we have no issue in asking them if they don't have a registration for the conference to please leave the conference room. That's what you need us to do.
That's what we
Is there a
need you to do.
registration needed for this conference?
Yes, and it's a private conference, dues have to be paid.
If y'all will show me who we asked to leave,
I'm going to direct you to them because I have not seen this person.
Let me. Sir, I'm David Toulis. We'll move around.
Sir,
Did you comply with Rule 30? You give a notice? If you can't, you've got to listen. It is. It's a judicial proceeding.
I have a right to be here. This is a judicial proceeding. I'll turn off my camera, but I have a right to be here. If this man is correct, it's a judicial proceeding, then I have a right to be here because the courts are open in Tennessee.
okay.
Which is it?
Well, they have told you that you're not allowed to be here, so I'm going based on what they're saying.
Okay.
Sir.
No, you're not going up there.
You need to step outside in the hallway.
I'm here to cover
I understand,
Private
and I've
events.
noted.
Management has asked you to leave, so it's time to leave.
I'm here. I'm David Toulis.
I know who you are, David. And you're
radio.
not a member of this conference.
No, but this
and
is
they
a
have
public
asked you to
event
leave.
paid for by taxpayers. And it is a. I'm here under Article 1, Section 19 of the Constitution.
Duly noted, please step into the hallway.
Here's my right.
Okay.
I have a right to be here, just as these people are who have to be here by duty. They're here by duty. They have to be here under the statute.
And
I have a right to be here, and I'm here volunteering myself in because I'm covering this event.
This is a public meeting.
It's not a public.
It's not a
It's our
public
president. If I could have the police.
I understand that.
But if we could step out, I'll be happy to continue to talk to you.
You are an agent of the state. This is a public meeting. I have a constitutionally secured right to
I
be
was going to
here.
ask you to walk out. We'll continue this conversation outside, but right now, they have rented this room.
I understand
They
that.
have the right to have anyone with a badge on
Sir,
there.
no,
If you don't have a badge, I'm going to have to ask you to leave the room.
I understand that, and what I'm explaining to you is this is a public meeting, and I have a constitution. The state cannot meet behind closed doors. I don't have to have a badge for the conference.
There were dues, there were registrations paid to attend this conference. You did not pay to attend this conference. I need to ask you.
I'm a member of the press.
If the director of this says it's a paid conference, you have to be registered to be here at the conference, and you're not invited, whether you're president or president.
I'm going by what they say.
I have a
I know you say a constitutional right. I know, but then they say, well, no, you have to be a registered.
Can I show you the law?
Making sure.
I mean,
You have it on you?
Yep.
I absolutely do.
Let's sit back here and look at it.
I'd like to stay here to look at it. If it's just simply an educational meeting, I don't understand.
I don't know what it means about. I don't know anything about what's going on. All I know is the hotel staff who owns this says that the registered person, yeah, you're going to be trespassed.
You're trespassing in the middle.
I figure that that's probably what it's going to be, and I'm okay with that. I'm prepared. I've already got a habeas petition in my pocket right here, so I counted on that. I would advise you guys to contact your corporate legal team before you violate my civil rights, which under Article 1, Section 19 of the Constitution, I do. We also have in Tennessee something called the Open Meetings Act, which this right here constitutes an Open Meetings Act. This constitutes a meeting of public officials under Title 8, Chapter 44 of Tennessee Code. So they can trespass, they can do whatever they want, but the judiciary cannot meet in secret. It is a public policy of this state that meetings not be conducted in secret. But the state cannot come onto private property in circumvention of the Open Meetings Act. That's what they're trying to do. And they're using her as a mechanism to try to trespass me so that I can't be here. But I have a constitutional right to be here because it's a public meeting.
Sir, all I can tell you, it's private property. You're
understand.
not registered.
I understand
need
that.
to ask you one more time, please, to leave this meeting.
I can't do that,
You're
ma'am.
going to
I
have
have
to
a
leave
right.
one way or the other.
I have a right to be here.
So you're going to have to leave one
If
way
they
or the other.
if
So,
I'm arrested, then they can do that.
gentlemen,
but
as far as
and
I'm
prepared
concerned,
to
he's
do that if that's the
trespassing at this
case.
point.
All right.
Okay,
You're
sorry.
trespassing. Hop on out.
Okay. Are you going to arrest me?
Right now, you're still being detained while we decide more.
Okay. Let's go out here.
I don't know what to tell you. Private property.
The
The
state.
lady from.
state?
Let me finish my
Go ahead, I'm
sentence.
sorry.
The lady who is managing this private property says, "You out." So I'm following.
And if that's
And if that's an infringement of your rights,
it is an infringement of my rights, and if you guys need to arrest me, please do that, is because it will create a constitutional crisis. I have a constitutional right to be here. And I also have a application for acknowledgement of public right of access that I issued to Chief Justice Page yesterday. Haven't heard back from that. This is a taxpayer-funded event. You have one political body making policy recommendations on administration of public justice. That's being done behind closed doors. That cannot happen under our state law. If they want to try to trespass me, please cuff me and let's go.
No, I admit it. I admit from what I'm hearing. Like I said, I just walked out. I don't know who's
I
in
understand.
it,
I
what's
got
the
it.
meeting about. But when all I can go by is, hold on just a second.
So who is him?
Okay.
Someone different?
Mr. Tullis.
I'm David Tullis with Nougat Radio. Hello, ma'am. I'm a reporter.
I understand. At this point in time, you are trespassing on a private event, on private property. I'm going to ask you to leave, please. They've rented this space. This is their space. You are not registered to be in their conference, so I do need to ask you to leave at this point.
And may I ask who you are, please? What is your name?
My
and
name
your
is Lisa Hegwood,
Hegwood, and
and I work
with
for the
whom?
hotel.
Yes, ma'am.
Okay?
Well, this
So please.
ma'am, this property has been ceded to the state for this event. It's not a private property anymore. This is a state body. This is a state piece
Sir,
of property right now
I
by
understand you're
easement.
upset, and I understand you're trying to do your job, and I'm just trying to do mine.
I appreciate that.
Okay?
Thank you.
So please, if you don't mind, would you please leave the event?
No, ma'am. I'm so sorry.
Gentlemen, at this
Sir,
point in time, I'm going to ask you,
please stand up
he
and
is
leave.
trespassing on this property.
Mr. Tullis,
Yes, sir.
please. You'll have your chance to redress this, but
No, sir.
right now you
No, I'm sitting right here.
you'll be trespassed if you do not leave, sir.
And who's
wait.
against whom?
This is against you.
Trespassing against which party?
You
Who's the
with
offended
Embassy
party?
Suites. Embassy Suites are the ones that are trespassing now.
They have not been in any way injured. Neither has the conference in any way been injured by my presence
That's
here.
going to be up to you to take it up with the Embassy Suites, with their corporate office. They are
that's
going to
convenient.
trespass you to leave. So we're going to
That's
ask you
very
nicely
convenient that
to
you
leave.
can, the conference can put this on the hotel. The corporation now is liable for this action. I
hotel.
don't think that's proper.
Well,
Is there a judge going to say
No,
that
yes, sir.
this needs to be a conference? The conference needs to trespass me. That needs to be what happens.
okay. Well,
The
it's
conference needs to trespass me if that's what's happening. It's not happening.
Yes, it is.
I'm not a
hotel is-
trespasser.
the hotel
I'm
is-
here as a member of the press. This is a public function paid for by taxpayers. I have a right to be here.
You're going
I'm
to
not
take
leaving.
that up? Take
No,
that up
I'm not
with
taking it up
MC?
anywhere.
Yes, you are going to leave.
No?
Mr. Toulis, please stand up.
No.
Jeff, come on in here. We're supposed to get physical.
Okay, then at this point, you're under arrest. Stand up.
Okay. No?
Stand up.
No?
After Mr. Toulis repeatedly refuses to leave the conference, he is placed under arrest for trespassing. According to Section 39-14-405 of the Tennessee Code, quote, a person commits criminal trespass if the person enters or remains on property or any portion of property without the consent of the owner. As the Court of Criminal Appeals of Tennessee explained in the 2024 case of State versus Hall, a jury may infer that a defendant knew they did not have the owner's consent to remain on property where notice against remaining is given by personal communication from someone with apparent authority to act for the owner. Here, Mr. Toulis was clearly told by a hotel employee that he was not authorized to remain in the conference room. However, Section 39-14-401 of the Tennessee Code defines the term owner for the purposes of this statute as, quote, a person in lawful possession of property. Accordingly, there is an argument to be made that the Tennessee Municipal Judges Conference, as the temporary lessee of the hotel conference room, constituted the temporary so-called owner of the property for the purposes of this statute, which would bestow upon the conference the authority to decide who may enter or remain on the premises. Nonetheless, it seems that Mr. Toulis was aware that he did not have consent from the hotel or the conference to remain on the property, and therefore that his actions fell within the statutory requirements for trespassing under Tennessee law.
I'm not going to do that.
Go ahead, put that down. Stand up for me, please. Don't make a scene in here, please.
No, sir, I'm not going to stand up. You have to carry me.
We will.
Okay.
Stand up, Mr. Toulis. Mr. Toulis, please stand up.
Is this talking to you?
Don't make,
Look, I have the strength to report the news.
don't resist arrest. Okay, then stand up and makes it easier.
Make it easier.
Okay.
Would you like us to
I have
get EMS here so that you can...
I have strength for all kinds of things,
Okay, well,
but I
stand
don't
up.
have strength to assist you in violating my rights to be here. I have a right to be here, and I do not have the strength to stand up to help you do that. I'm not going to cooperate, okay?
Mr. Toulis, I'm going to ask you one more time, okay?
I don't have
If
the
you don't-
strength to do that.
I understand that.
I
I'm
don't
going to
have the
call
strength-
EMS here to have you wheeled out. Is that okay?
Please
Or
do
would you
that
like to
because-
walk out on your own?
No, I have a hernia. Please,
415.
I do not have the strength to cooperate in my unlawful arrest.
Okay.
I'm a member of the press. This is a public event, and you're going to let me be kidnapped by these officers without warrant. You have a duty.
No, because right now it's trespassing.
No, it's not trespassing. This is a public venue. This is the easement of this event. It makes this not a private
Okay, you talk over.
place.
Go ahead.
Your Honor, this is a secret event. I'm trying to cover it. Judge Bean, I'm trying to cover this event. Why is it a secret? The Open Meetings Act says nothing shall be done in secret in our government. Can't be done in secret. I do not consent to this. I do not have any medical problems. But is this a gurney?
You said you had a hernia.
I do have a gurney, but I'm not. It's not. You know. It's not ruptured.
We're going to go get that checked out. Come on with me. I have to see you right there. Scoot on back a bit. There we go.
And where are you taking me? I'm here to see the magistrate. I have a right to see the magistrate. Is that where we're going? Yeah, I have a right to see a magistrate before booking. Before booking, I have a right to see a magistrate and have my case ready.
Have y'all got my card?
Yeah, I do. Thank you.
If you're a magistrate, I can at least vouch that he's lived, this is where he's lived, he's a peaceful person.
Okay.
This is.
Oh, yeah. He's
Okay.
just...
Mr. Toulis repeatedly refuses to stand and walk out of the room after he is arrested, so the officers call for EMS and he's wheeled out on a gurney. According to Section 39-16-602 of the Tennessee Code, quote, it is an offense for a person to intentionally prevent or obstruct anyone known to the person to be a law enforcement officer from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer or another. In the 1992 case of State v. Corder, the Court of Criminal Appeals of Tennessee determined that the use of force was a necessary element of the offense, and therefore that there was insufficient evidence to support a resisting charge against an arrestee who refused lawful orders to get into a patrol car, but did not physically assault the officers. In reaching this conclusion, the court noted that, quote, in states which have statutes which prohibit resisting arrest or official police orders without the use of force being required, the defendant's conduct would probably be deemed an offense. However, we do not believe that the statement of the evidence in this case reflects sufficient proof that the defendant used force, as is required by our statute in preventing or obstructing his arrest. While applying this case law, the Tennessee Attorney General indicated in Legal Opinion 00-147, issued on September 26, 2000, that, now quoting, an individual who intentionally but passively refuses to obey a law enforcement officer's reasonable, lawful command does not commit an offense under Tennessee law, because force is a necessary element of resisting arrest. Accordingly, it is unlikely that a court would conclude that Mr. Toulis's refusal to cooperate with his arrest rose to the level of resisting arrest under Tennessee law.
Meet us out at the,
If she's gonna trespass me, can I get that in writing?
that'd be up to them. We heard her say you are trespassing, so that's enough for us.
Is your body cam on by chance?
Absolutely.
Okay.
I don't go anywhere without it.
Can I get some information from you so I can get that under open meetings act? That's all right? You have a card?
Yes.
Trooper, thank you very much. It's very kind and polite. I really appreciate that.
All right. Have you got a card as well?
I don't, but I'll be happy to write my name and information down.
Only that he's a member of the press. You guys transported him?
We just they wanted him out, so now he's out. What do you want to do?
I gotta check with the sergeant. I mean, if we write him a cite and kick him loose, he's gonna come back, so we gotta take him, I guess.
We as in EMS or we as in law enforcement?
Law enforcement, but he's gonna be...
You decide. We're not going anywhere till you decide what you want us to do.
Let me find out from the sergeant. So, if we ask him if he gets cited and released, is he gonna come back? And if he says yes, then we're gonna take him?
Yeah, we can do that.
Okay. So if he refuses this, I'm going to go back, then we're taking him. Do we just drive him right to the jail? Okay. And have him get him straight to the jail?
But it's a misdemeanor. Thank you. I'll give you it's a misdemeanor, and it's going to continue if we don't take you custody.
I'm going to go gauge his So they're not going to give it any more problems. They've made their statement.
The judges are a little nervous about walking out to their car. I'm like, look,
They're gonna be out of here.
they'll talk you to death. That's about the biggest threat they have.
But if anything else, give us a call back. Come back.
What's that?
Thanks, Sergeant. If anything else, just give a holler.
Appreciate it.
Appreciate you.
Mr. Toulis was issued a citation and charged with criminal trespassing, and on December 14, 2021, the case was dismissed after a 70-minute hearing where a judge ultimately found that there was no probable cause to support the charge. No additional information regarding the basis for this determination is available. On November 9, 2022, Mr. Toulis filed a federal civil rights lawsuit seeking $3 million in damages. However, on April 28, 2023, the case was dismissed because it was not filed within the one-year statute of limitations for filing a claim. The judge explained that, quote, instead of promptly pursuing his claims, plaintiff sat on his rights and waited until November 5, 2022 to sign his complaint and place it in the mail for certified delivery to the court. He thought that this sufficed to have his complaint filed within 1 year from the events of November 6, 2021. This was a significant mistake. A civil action is commenced by filing a complaint with the court. As the Sixth Circuit has clearly stated, if mailed, the filing is accomplished only when actually received received by the clerk or when placed in the clerk's post office box. In other words, because Mr. Toulis's complaint was not received until November 9th, it was considered untimely and therefore dismissed, even though he mailed it on November 5th, which was within the one-year period. Mr. Toulis appealed this dismissal of his claim to the Sixth Circuit Court of Appeals, and on August 19th, 2024, the court affirmed that his case was correctly dismissed as untimely filed. Additionally, the Tennessee Supreme Court Administrative Office of the Courts enacted Administrative Policy 3.04 regarding so-called attendance at AOC conferences, effective February 1st, 2022. The policy clarified that the term conference referred to, now quoting, a formal education-centered gathering of current or former members of the Tennessee Judicial Conference, Tennessee General Sessions Judges Conference, Tennessee Conference of Juvenile and Family Court Judges, Tennessee Municipal Judges Conference, Tennessee State Court Clerks Association, or current appellate law clerks and staff attorneys who work in a full-time or part-time status, and stated that, now quoting again, conferences are not open meetings. Only conference attendees, invited speakers, and staff will be permitted to enter the physical conference spaces or receive virtual access links. Now, in response to the enactment of this new policy, Dan McCaleb, executive editor of the Center Square news outlet, filed suit in federal court on June 13, 2022, requesting declaratory and injunctive relief to stop enforcement of the closure policy. However, after Tennessee Deputy Attorney General Janet Kleinfelter argued that, in practice, the conference meetings are, quote, confined to educational sessions, the parties agreed that injunctive relief was, quote-unquote, presently unnecessary, and the court denied Mr. McCaleb's motion. Accordingly, as of the date of writing this episode, the conferences remain closed to the public. Overall, Officer Orange gets an A for remaining calm and professional throughout the encounter, exercising extreme caution and discretion while dealing with a nuanced legal issue, and for making a legitimate effort to understand the situation before blindly arresting anyone. From the moment he arrived, Officer Orange was thrown into a complex legal dilemma that demands expertise beyond the scope of a traditionally trained officer. While there is no doubt that officers should be expected to know the law to some extent, it would be unreasonable to demand that members of law enforcement possess the same degree of legal knowledge as an attorney. Now, at one point in the video, Officer Orange asks the hotel staff to inform Mr. Toulis that he's being trespassed. While some may interpret this as an attempt to solicit a trespass, it is important to bear in mind that this request was made on behalf of the conference members, who had already requested that Mr. Toulis and Mr. Sapp leave the conference room. As mentioned earlier, this was not a public event, and the conference leaders did retain the authority to trespass the journalists from the conference room, and Mr. Toulis's arrest appears to have been lawful. It is unclear why the judge found no probable cause for the trespassing charge against Mr. Toulis, but it could certainly be related to procedural errors, political agendas, or simply judicial fatigue rather than a lack of merit. It is also worth noting that Officer Orange remained calm and collected throughout the encounter and exhausted every possible resource before ultimately making the decision to arrest Mr. Toulis. I commend Officer Orange and the Franklin Police Department for navigating this interaction with professionalism, diligence, and courtesy. Mr. Toulis and Mr. Sapp get an F for demonstrating fundamental misunderstandings regarding the framework of their protest and constitutional law in general, for forcing the Franklin police officers to effectuate a legitimate arrest on Mr. Toulis, and for failing to follow up this encounter through the proper legal channels and procedure. Although Mr. Toulis and Mr. Sapp had every right to be suspicious of a closed-door conference involving judges, especially one that discusses sensitive topics like sovereign citizens, that doesn't mean that they had the legal right to stay without permission. Mr. Toulis and Mr. Sapp anchored their refusal to leave on the belief that they had a constitutional and statutory right to be there. However, as mentioned before, the Tennessee Constitution protects access to government proceedings, not professional training events. The journalists cited Article 1, Section 19 as though it gives carte blanche to attend any meeting involving public officials. But there is a clear legal distinction between official proceedings and educational seminars. Furthermore, after somehow managing to avoid the trespassing charge, Mr. Toulis allowed his lawsuit to be dismissed on procedural grounds by failing to file it within the appropriate time frame. Considering that Mr. Toulis has filed several pro se lawsuits in the past against various entities and individuals, and regularly reports on issues involving the judicial system, the statute of limitations and procedural process is something that he should have been familiar with. And if he truly believed that his rights were violated or wanted to advocate for changing the structure of current legal framework surrounding closed judicial training events, well then following the proper legal legal procedure is the most basic step he could have taken to achieve either of those goals. By the way, it is also worth mentioning that Mr. Toulis and Mr. Sapp's tactics actually resulted in the opposite effect from what their actions were intended to induce. Rather than forcing more open training sessions, the Tennessee Supreme Court Administrative Office of the courts went on to draft official policy to explicitly exclude the public from educational gatherings. While I do commend Mr. Toulis and Mr. Sapp for their passion for civil rights and professional demeanors, I also believe that they failed at nearly every level to make a legitimate point and caused real, practical harm to their own mission of judicial transparency. Few things undermine a cause more than advocating for change while misunderstanding the very rules that you're fighting against. And this interaction is a prime example of the importance of being informed before becoming passionate. The conference leaders get a C- because although they were within their authority to trespass Mr. Toulis and Mr. Sapp, they also demonstrated a blatant disregard for public transparency, placed the Franklin police officers in a legally ambiguous position, and then went on to enact further exclusivity rather than more transparency and accountability. There is no denying that the current constitutional and statutory framework granted the conference members the authority to exclude members of the public. However, just because the law allows secrecy doesn't mean that public officials should be allowed to use the letter of the law to hide from public scrutiny. The education that these judges were receiving at the conference was paid for, at least in part, by public tax dollars, and the content of those sessions shapes how they interpret and apply the law in situations involving average citizens. Closing educational conferences to the public breeds suspicion and warrants citizen questioning and probing, especially when the content of these conferences involves a controversial topic that directly intersects with First Amendment rights, police encounters, and legal philosophy. Rather than taking this opportunity to reevaluate their policies, the Administrative Office of the Courts doubled down by enacting Administrative Policy 3.04, which formalized the closed-door policy for all judicial conferences statewide. And it could certainly be argued that this was an act of institutional self-protection masquerading as policy. By the way, it's also important to mention that the conference leadership put Officer Orange and the other Franklin officers in an extremely taxing and legally questionable position by refusing to take ownership of the official trespass notice. Any well-managed judicial conference should have clear, prearranged protocols with hotel staff about how to handle unwanted visitors, including who speaks for the property, who gives orders, and who calls the police. That lack of clarity forced a field officer to make an uninformed judgment call that potentially carried significant legal consequences and political fallout. I find it particularly troubling that a room full of legal experts failed to understand the legality of a situation that unfolded right before their eyes, and that none of them were willing to take on the legal liability of issuing an official trespass notice to the journalists. Not only does the conduct of the conference members lend credence to the claims of the journalists, but it also reflects an attitude of bureaucratic self-preservation at the expense of public trust. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the description below.